the forms you need. Also, just kind of some tips about working on a case, and then the other steps about hearings and appeals counsel. We'll also talk about the benefit rates, and then then we have some questions. Before we get into it, I did want to conduct a poll to get a general sense if people have some experience working with Social Security and CAPI. So for that, I am going to pass it to Jeremy to conduct the poll. So the first question is, have you ever worked on SSI, SSDI cases? Never, a few, or over 10. And then the next question is, have you ever worked on CAPI case? Again, never, a few, or 10, over 10. So we'll give it a couple minutes. A couple seconds, actually. So it looks like we've got a broad range here. And a couple people have handled a bunch of cases. We've got various levels of experience here. So that's very exciting. So if this is new to you, great, we can go into more. If this is something that you've done a little bit of time, I think you'll find some of the information we find helpful. So going back a slide, let me just pull this back. So what's the difference? What's SSI? What's SSDI? What's CAPI? So SSDI is Social Security Disability Insurance. I'm also going to refer to that as Title II because that is where it's found in the law, is Title II. It was created before SSI. This is a program that you have to qualify for by putting in 40 quarters of work. We'll get into a little bit more about what 40 quarters of work are, and also what happens if you're not of the age where you wouldn't even have enough of 40 quarters of work. The next program is Supplemental Security Income, commonly referred to as Title 16. This is a means-tested benefit provided by Social Security, and you've got to apply for all other benefits to be able to access this benefit, such as veterans benefits. And finally, CAPI, Cash Assistance Program for Immigrants. This is a unique program to California, and that is for people who don't qualify for SSI or SSDI. And you have to apply through your local office. Now, processing times. This is a map that I just pulled off the website from Social Security. You can see the areas in red. You can see San Francisco kind of there is over 25, the other area 25 days in processing at the field office. However, when we look at this, the initial claim period is kind of really slowed down right now. That's just due to staffing issues with both Social Security and the California agency that processes them. So right now we're looking at a turnaround time of about 7 months. That's kind of that's the average. So that can be longer than that and shorter than that. The processing time first starts in the field office. Currently in the San Francisco field office, they are anywhere from 25 days to 60 to 90 days processing an application. And that's simply because they're very understaffed right now, unfortunately. There are 3 field offices in San Francisco, so that's not across the board. Some offices have more staff and are a little bit more expeditious. And the next thing is DDS, that's Disability Determination Services. I'll get into a little bit more about what that does, but what they do is they complete the medical review. So as you can see, the country, we're all kind of getting a little slow right now. They are working on backlogs. For reconsideration, there is a considerable wait. Over the summer, the California office was not even processing reconsideration requests. So we've had some cases of reconsideration that have been sitting for 9 months. And I'll give you some tips about how to move your case along if it's been sitting for a while. Here is the application process. This is from Social Security. This, you can see kind of how they process things. So first of all, you'll submit your application. We'll go into all the paperwork that you need for that. Social Security, that's the field office that you submitted to, is going to review your file for eligibility. They're going to look at income and asset limitations. They're going to see if you have any quarters. This is the SSI application process, but it's essentially the same for SSDI as well. So after they review your file, they'll contact you if something's missing. Maybe a form isn't signed. Maybe they need some more information about you or your work or your client or your client's work history, or anything about their disability. They will let you know what's wrong if they're missing something. If it seems like you're not getting your paperwork isn't getting processed, you can also reach out to the local field office and see what's going on, why they haven't contacted you. Generally, if you sign on as a representative, or an application gets processed, you will get a notice from Social Security saying that they've received your application. In the case of representatives like myself, we get a notice that says Social Security's received your application. We've received your notice that you are signed on as a rep. So after all of your paperwork is ready to go, it's done from the field office. Then what it does is it gets sent to DDS for disability evaluation. That's short for Disability Determination Services. DDS, every state has a separate DDS agency. The federal government gives a grant to our hire contracts with every state. And so the state, in our case, California CDSS, is the person that hires DDSS. So there are a lot of acronyms. So let me know, I could go a little slower, but it all eventually will make sense. So DDS is a California state agency. Their process is to collect medical evidence for medical review. What they're doing is they're essentially doing all of the paperwork needed to be able to send your information to a doctor to determine whether you have a disability. So when you're communicating with your DDS person, you'll be assigned a DDS claims representative. They'll contact you for some forms. They'll also request medical records. You can submit medical records. This is the person that you're going to want to be in contact with to see that everything is being received, that they have all the information, like where your client's going up for healthcare. And essentially, all these claims really rely on healthcare. It's essential that your clients have some sort of medical records to be able to support their claims. As you see, the DS will request your medical records. That's the third one. And then if there's insufficient evidence, DDS might request a consultative examiner. Now, this is a doctor that is paid by Social Security to conduct an evaluation of your client. Whether they're good or not, it's probably not the place to comment on it, but some doctors are better than others. Although what I can tell you is some doctors will only spend like 5-10 minutes with your client. And a lot of our clients have thousands of pages of records. It's really very challenging to be able to conduct a comprehensive medical evaluation with someone in about 10 to 15 minutes, particularly if someone has complex medical issues, more than one, back issues. They will sometimes conduct the necessary testing to see what kind of strength issues we have, depending on the kind of limitation that you are claiming. But consultative examiners, and this is something we can discuss a little bit more, sometimes provide good evidence, sometimes don't provide good evidence. But if you are signaled by DDS that you need a medical examiner, that tells you that you don't have enough evidence. So make sure to check with DDS to see that you have enough medical evidence, that they have all the records. Because if you have a lot of records and a lot of doctors' opinions, then you don't need a consultative examiner because you'll have enough information there. And so after that, once the analyst feels like they have enough information to make a decision on your claim, then what they'll do is they will send it to an actual medical doctor for medical issues, or for physical medical issues, or for a psychologist or a psychiatrist if there's also mental health issues. Now, in the case where you have both mental health and physical health, your client's case file will be sent to both doctors to see if they meet, well, we'll go through the process, but to see if they meet the requirements for a disability, either physical or mental. And then after that, the doctor says, yes, you meet the requirements. You get approved or you get denied if you don't meet the requirements. This is the life of an SSDI claim. These are generally the times, this is from, I believe, they haven't published the times that it takes, or the percentages allowed for 2024. So I think this is probably from 2022. But you can see that at the left hand of the screen, we start with the initial application, goes to DDS, depending on how easy the case is, how long it takes them to request records. Development could take 2 to 6 months. If you are approved, terrific, about 38% of cases get approved. If not, then the next stage is reconsideration. That is simply just a term for an appeal. Now, some states don't even have a reconsideration. And indeed, when we talk about CAPI, CAPI will follow these exact steps, by the way. However, CAPI does not have a reconsideration level. So there is no reconsideration for CAPI. You go straight to a judge if you lose that initial. But once you're at reconsideration, then you will go back to DDS and they will collect more medical records. As you can tell, this kind of takes a while to process. So if your client doesn't have a lot of records and they're at reconsideration, it's a good chance for you to try and get them into healthcare so that you have a little bit more time to develop the case. If you get approved at reconsideration, which is a very low number, you can see it's about 15% here. Great, you prevail. If not, then you can appeal to a hearing before an administrative law judge. There are offices all around the country, all around the state for ALJs. There's a much higher, as you can see, approval rating for hearings with ALJs. And that's simply because it's the first time an attorney is actually looking at the case. It gets worked up through a somewhat different lens. It's the same exact lens that Social Security uses at all the steps along the way. But this is when you could start putting some arguments. Now, if you get denied, then you have another further appeal to the Appeals Council. That's an internal agency, or that's an internal part of Social Security, and 2 judges will review the prior judge's determination. If you don't get approved, then you can appeal to federal district court. Federal district court, we only take cases that we feel will prevail because you don't want to clog up the systems, but there's also a very high success rate when we go to federal district court. I will say the Appeals Council rate is 13%. Doesn't look that great, but we have been seeing a lot of remands recently. I think because they probably don't want to go to district court because they don't want to get all these bad decisions saying, hey, you did this the wrong way. So that's essentially the life of a claim. You're looking at potentially a couple months to a couple of years, depending. I have cases at hearing right now that have been waiting for about 2-3 years, which can sometimes be a good thing if your client doesn't have good medical records or doesn't have a history of records. Now, eligibility, okay, this looks like a lot, but we'll just kind of go through it and it gets a little bit more, you can understand a little bit more as we read through it. So 40 work credits, what does that mean? That essentially means that you get a credit for every $1,700 in wages or self-employment from each quarter. So you can earn 4 credits in a year. So essentially to get SSDI, you have to work for 10 years making over this amount. Now, if you have, as you can see, if you're a different age, there are different requirements for the amount of credits that you need. Here's a pro tip. If you don't know how many credits your client has, have them create an account on mysocialsecurity.gov or whatever the link is. It's very easy. It takes about a couple minutes. If your client's with you, great. They can see exactly how much they would be qualified for, how many credits they have, how much their SSDI might be, how much they might even have in retirement benefits. It's also really crucial to know that number because sometimes the SSDI number is lower than the SSI amount. And so when we talk about applying for SSI, some people for SSDI might only qualify for $400 or $500 of SSDI. Now, SSI is a lot more than that, not a lot more, it's a little bit more. So that's when it comes into play that you want to make sure you apply for both because you can get SSDI and SSI. Now, SSI, to be eligible, that's actually correct. You can be eligible for SSDI, but SSDI amount is lower than the monthly SSI. The SSI amount, let me rephrase that. Like that situation that I just told you, if you have a low SSDI amount, you can also get an SSI amount. Okay, these 5-step sequential evaluation process. This is how Social Security analyzes everything. These are the steps that Social Security looks at, as does CAPI, to determine if you have a disability. And the steps that you can be found disabled are 3 and 5, but let's go through them from the beginning. The first question is, are you working? This is very easy for Social Security to tell people no at, because if your client's making what we call over SGA, substantial gainful activity, then Social Security is going to say, no, stop, you're actually working, that doesn't work. For 2024, that means an average of over $1,550 a month. You can't be considered to have a disability. If you're working and not earning SGA, then it is sent to DDS to process. And if you are earning over SGA, there are some exceptions. It gets very into the weeds, so I don't want to get too much into them. But there are some ways you can reduce your earnings. Maybe if you have expenses that you use for work. There are ways to whittle down. It's not the best way, but if someone's working, that's a red flag for you right now. If they're earning over $1,550, you got to ask yourself whether they're going to be denied at step 1. And if they are earning over $1,550, I probably wouldn't move forward. Again, situations can be different. General rule. Next question is whether your condition is severe and expected to last a year, 12 months, or will last, has lasted or will last over a year. Now, this is the way Social Security defines severe is by statute. You can take a look that the conditions must significantly limit your ability to do basic work activities such as lifting, standing, walking, sitting, remembering, but it's a very low threshold. And indeed, the courts have found, particularly in the Ninth Circuit is very helpful in terms of Social Security, that it is what we call a de minimis standard, meaning it's a very, very low threshold. There is a case for all the folks that are interested called Buck v. Berryhill, in which they claim, they write, the Ninth Circuit that is, says that it is merely a threshold determination meant to screen out weak claims. It's not meant to identify impairments that should be taken into account when determining the residual functional capacity. So again, a severity, if you get a step 2 denial, that is a very easy thing to appeal. Getting more into the weeds, what determines if a condition is severe, there have to be some sort of notes from a doctor, or that again, that it affects, your client can claim that does affect these a full range of work activities. The next one is what we call the listings. Is your condition found in the listing of disabling conditions? For this one, this is the very first part that you can be found disabled. And I believe you can see this. This is what a listing looks like for depression. So for depression, you've got to have 5 of these different symptoms. And this is the one for bipolar. On top of that, that's the A criteria that we see. Then you have to have an extreme limitation or marked limitation in one of these, either one extreme or 2 marked limitations. These are technical terms. Generally, marked means you have a limitation of 20% or more in any of these realms. Extreme is a little bit more than that. It depends on the court, depends on the circuit, and also how you define extreme and marked. There are forms that we give to doctors called residual functional capacity forms or mental impairment question forms that help us define exactly what this means. There is a link to this where you can see the entire adult listings here that has pretty much every single realm of the body disorders. Now, there are a lot of things that are left out. So if you aren't able to find a listing, there are what we call equivalences, where we can find certain impairments might be equivalent to another impairment. So great, if you meet all the requirements for a listing, terrific, you are found disabled. Again, the key to everything is medical records. You need a doctor, and you don't have to have a form from a doctor, but you do have to have some sort of records that show that you meet a listing. Generally, for like mental health, for example, you can look to the mental status exam in medical records that will show it, or symptoms an area. For physical records, look at the review of symptoms. And there are other areas in the records where you can find it. One thing to note when you are looking at records is to make sure, and there's nothing you can do about this except for talk to the doctor. It's oftentimes with a lot of the new software that we have, doctors can it's very easy to cut and paste a lot of things. So you might find that the same symptom of depression is repeated over and over and over, yet a client might not have all these symptoms. They might not have all these symptoms of depression all the time, or maybe they have more. Maybe they're suicidal one week and they're not the next week. So when you are looking at these, take a look at the records and see if there are any typos or anything that you can see where you just see the doctor might have just cut and pasted, because it doesn't really help very much for our clients if they cut and paste all the limitations. But again, symptoms and limitations are what we're really looking for. So a notation of symptoms. The next one is step 4. That looks at your past relevant work. So what Social Security, this is if you didn't get found disabled, it's step 3. Then we go to step 4. Maybe we can mute all.
Hello, sorry I'm late.
Sorry, we muted you also, Michael. Michael, you need to unmute.
Hi, sorry. Okay, we'll go back to past relevant work. So past relevant work is not the next step. If you have not been found disabled at step 3, then we look at your work. Now, this is an exciting one for Social Security because they just changed the rules to look back only 5 years. It used to be that they would look back to every job you had in the last 15 years. But this just changed this year, which makes it really helpful. So what Social Security essentially does is they say, okay, look, you used to work as a secretary. Can you return to that job? They look at multiple metrics that they have, the DOT, to see if there is the job definition, what the kind of work you did. So let's say, well, actually change it to line cook. For a line cook job, for example, you might have had to lift and carry 25 pounds. I'm just making this up, by the way. 25 pounds, 6 hours out of the day, and you had to lift and carry 10 pounds, 2 hours out of the day. What Social Security is going to do is look at that job, and then they're going to look at the profile that you have. Let's say you're claiming a back condition and knee issues and maybe a couple other things. And when Social Security takes a look at this past job, they say, okay, can you do this job where you can lift 25 pounds, 6 hours a day, even though you have severe degenerative disc disease? Usually the chances are that they're going to be able to say that, no, you can't do your past relevant work. If they say you can do your past relevant work, that's a denial. If they say you can't do your past relevant work, then we move on to step 5. And again, the past relevant work is defined specifically by Social Security. When we do the application, you will have a chance to talk about what your past work was, and also any variations that your client might have in terms of the past work that that is kind of recorded by the DOT, the requirements of the job, as opposed to what it was actually performed as. So then next they say, okay, great, you can't do your past relevant work. Let's look to see if we can find you disabled based on any work, or deny you based on any work in the national economy. So what Social Security will consider, again, they do this for past relevant work too, is they look at your medical conditions, your age, your education, your past work experiences, and any transferable skills you have. And when they take a look at that, what they do is they will say, again, they will make this profile of you, of who you are as a person, your client is as a person, and with all of these realms, and say, well, is there any work you can do? So let's take that example of someone who used to lift 25 pounds, 6 hours a day. That's going to whittle down a lot. If you have like severe degenerative disc disease, for example, odds are your doctor is not going to want you to lift anything at all. So that eliminates all of these jobs that are that have a really high criteria of lifting. Their Social Security will classify jobs as medium, light, sedentary, or heavy, and those all are basically go down to what kind of activity you can do, how long you can stand, how long you can sit, what you can carry, what you can't carry. And so when you get to the kind of jobs in the economy, Social Security will tend to come up with some really odd jobs. The DOT hasn't been updated in, I think, 30, 40 years or so. So a lot of the jobs are out of date. One of them is like tube operator. If you remember what that was, you'd stuff something into a tube, put it in a vacuum, and it would go wherever. A lot of copy machine operator is another one of them. A lot of the jobs are outdated. So it's a point where we could start arguing. But again, if Social Security finds that you have so many limitations that you can't really do any work, or that you, for example, let's say because of a mental health disorder, let's say you have problems concentrating, maybe anxiety or something, and your doctor says you can't concentrate for more than, you're going to be off task maybe 20% of the time, meaning you won't be able to focus. You'll need to take breaks 20% of the time. Most of the time, that is enough to find that you are disabled. So there are a lot of different ways we can get to disability. And again, that is going back, this is the process that both Social Security and CAPI will use to evaluate whether you are going to be found disabled. The initial application. So great, how do we even do any of this? The very first thing to be aware of is the protective filing date. This is essentially a bookmark in time for you. Let's say you, there's so much information to collect on these applications that oftentimes you'll find when you start an application, you might need to get more information. Well, Social Security gives you the opportunity to be able to put a bookmarker in time. It's pretty easy. You just need a little bit of basic information, Social Security number, name, birth date, and you'll be able to get this protective filing date. What this does is this starts the timer for you for your claim. Now, for both SSI and SSDI, you're eligible for benefits the month after you apply. So I'll say that again. You're eligible for benefits the month after you apply. So let's say I file today, October 22nd. The first month that my client can be eligible for benefits is going to be in November 2024. Now, a little bit of a caveat, that's really specifically for SSI. When we talk about SSDI, you do have the opportunity to be able to get a year back from the date you applied. So again, for this example, well, this is getting a little bit ahead of myself. I'll go back to the protective filing date and get back into the how long you have, how much benefits you can get. But starting the timer with benefits, you have only 60 days from the time you put that protective filing date in to file an application. Now, again, you don't have to file the application immediately. This starts the timer. So you've got 60 days to get all of your materials ready. For SSDI, you have 6 months. So you have a lot longer time to apply. So just make sure you calendar all of those things out so you have information, so you know when your deadlines are. How to file. You can see there's a website right here that you can go to. Now, the thing about Social Security benefits are they make it very easy for people to apply for Title II SSDI, very challenging for people to apply for SSI. Currently, you can put in a request to apply for SSI, but what that means is that you'll essentially get a call back from Social Security to complete your application. We don't really do that. So because it just, it's hard for them sometimes to call. Excuse me, but you can do the SSDI application online. And indeed, the way you do get a protective filing date is by starting the SSDI application online. So the application process gets you that protective filing date just by starting. Now, when you get the protective filing date, it'll give you a receipt number so you can save your receipt, print it out, write it down, do whatever you need to do to make sure you get that number, because you can save your application and come back to it multiple times. The other option is you can just call Social Security and put an application. Also, of course, you can go into the field office. That's another way to do it as well. Again, here you can see that you can do it online. There are also paper applications for the SSDI application. And this happens sometimes where you might have a client whose name is changed, or in other situations, maybe you didn't get a middle initial, or your client can't remember their birth date, or their birth date's off by a day or a year. It happens all the time. So in that case, what we do is we submit a paper application. It's Form SSA 16. Just Google it. You can find it. Make sure you have the most recent version, by the way, and you can find that at the bottom. It'll tell you when it was published. Now, the SSI application, drum roll, or maybe just excitement, is that we will be able to start allegedly applying online for SSI starting in December 2024, which is huge. We've been trying to get this for them for years and years and years. Now you should be able to start an application in 2024. I haven't seen the application, but people in the National Organization of Claimants Representatives, which is essentially the Bar Association of Social Security Claimants Representatives, is very excited about it. Has been pushing for it. However, until then, you still need to submit a paper application. Social Security did publish a brand new version of the paper application. It's called SSA 8000BK. That's what you'd Google to find the form. And you can find a PDF. Also, when you do download these forms, make sure that you're downloading off of Social Security's website. Check the URL, because there are nefarious companies that might say, oh, you can download from here, and then all of a sudden you've got something installed on your computer. So always check to find the source of these of any paperwork that I'm recommending. That should always be from Social Security, not from some third-party site. Again, you should be able to apply in December. For now, you'll still need a paper application. One other note in San Francisco is that they have really been pushing for what we call wet signatures. That means they want to see the ink on the paper. For a while, we've been faxing our applications. Best practices is to, what we do is we fax an application so that we have a receipt of the application being filed with the local office, just in case they don't get it, because like, as I mentioned earlier, there's such a slowdown in processing applications. They might claim that you are a month or two late when indeed you actually did file your application timely, and you've got the fax that shows that you filed it October 22nd. We do also send certified copies via mail. You have to send the certified copy via mail. So I would do both. And then here are the documents. The disability report. You will be getting this. You'll put in all this information about your client's disability, their doctors, any medication that they're taking, any tests they've had, and any past work. And so that'll be generated into a receipt that you could save and you can print out. And you absolutely must save that and print it out. If you're filing an application or filing for late filing with good cause, that means, for example, let's say you missed that 60 days for that protective filing date, but you have a good reason, maybe because a power outage or whatever reason. There's a whole CFR, Code of Federal Regulations, about what the good cause reasons are. And I can share those if we need them. You'll actually need to use a paper form. You'll need the form SSA 827, which is essentially a HIPAA disclosure, so that they can, you're authorizing Social Security to get medical records. This is really helpful. We request our records independently, but sometimes agencies or hospitals, for whatever reason, are a little bit slow to get the medical records. So it's very important. Social Security will always want to do their own independent records requests. The next one is the appointment of representative form, SSA form 1696. Social Security won't even talk to me unless I have this form in the file. There is another form that will allow you to talk with Social Security for just some questions. I'm blanking on the name of it, but it'll come to me in a second when I can give you that name of that form. Also, you'll have your PFD confirmation, the work history report. Again, that's something that will be auto-generated, but there's a chance that it won't be auto-generated if you have to do a paper application. And if you're doing that, you will need to submit SSA 820 or 821. And the difference between those is Form 820 is if you're self-employed, Form 821 is if you're an employee. Then also, there's a lot of forms. There is, for people that do not have adequate cooking facilities, another form called the California Restaurant and Meals Allowance. That's for folks that might not have a working oven or refrigeration. And if that's the case, then they will get another a couple $100 supplements. Okay, CAPI application. Now, this is a lot of paperwork. This is a pretty exhaustive list. So take a breath. It's okay. It's fine. We've got it. This is just so you kind of see what paperwork might be required. If you were to go to the CDS website to see what is required for CAPI, they're only going to tell you need number 2, SOC 814, the statement of facts. Now, this is essentially going to be the SSI application. One thing I should say is that you are going to have to apply for SSI and get denied, or show that you've applied for SSI before you can even start your CAPI application. So the difference for forms, so you always need to make sure that you've got your SSI application and verification that you've applied or that you're getting denied to be able to even proceed with CAPI. Everyone's going to have to contact their local social services agency, because there are different forms. They might require different forms. They might require less forms. They might require more forms. A couple of different things to keep note of here are there are multiple appointment of representative forms depending on what the program is and what you're applying for. If you're sponsored or not, you'll have to provide that. Your client will have to provide that kind of information. Again, to qualify for CAPI, you cannot be eligible for SSI or SSDI. And you also have to be there. It's very complicated. Not very complicated, but the requirements are laid out in the Manual of Policies and Procedures. And that I can show you where that is, about what the requirements are for applying for CAPI. So you see here, we've got a pretty exhaustive list of everything you'll need to kind of have in order. But again, you might not need all these forms, so make sure to contact your office. Some of these forms you might need in triplicate. There is one form that they do like to have in triplicate, which I believe is the MC 220. So those are the forms. Now, let's say you get denied. You've applied, you got denied. The next thing that you'll have to do is apply for appeal. And so when we appeal, we're appealing to reconsideration. Your deadline is 60 days plus 5 from the date of the denial notice. Now, make sure you look at the denial notice, because if you're on as a representative, the date, they might have a cover page with a date later than the date that you have on your denial. So always look at the page that says you are denied for these benefits to appeal. Another pro tip, if you already know your client does not have enough quarters to qualify for SSDI, you will get a denial letter. That's okay. That happens. Your client just doesn't qualify for SSDI. It's the denial letter from SSI that you really want to be on the lookout for. And you also know, because they can make denials for SSDI pretty easily, because they already know that you have enough quarters or you don't have enough quarters. For SSI, it's going to be sent to DDS. So if you have gotten a denial, but it hasn't gone to DDS, that tells you that you got a denial for a non-medical reason. That means it's a denial not based on your medical condition, but either a paperwork issue or you don't have enough quarters. But again, when we do the appeal, you're going to need a bunch of different forms. This is all available online, by the way. So once you get to this stage, you don't have to submit all this paperwork. There's a very rare chance that, again, if you have like some issues with a name or something, or your client can't remember their birthday, or some sort of typographical or minor error, you might have to do this on paper. But essentially, the request for reconsideration is very easy and very quick. It's a very quick form. The disability report, that 33441 form, that'll take a little bit more time. It's essentially you already completed it, so you can use the information that you used on your initial application for that application. And what that is really a lot of information about your impairment, or your client's impairment, and doctor information, testing, medical records. Again, you'll get the 827, that's the disclosure of information. And then if you need to if you have to file for good cause, there is a form that you can use for that. Non-medical appeal, again, that's for issues that are non-medical related. Maybe they got some paperwork wrong, or whatever the reason might be. Remember to always keep a copy of your submission. Working on a case at initial and reconsideration. When your case goes to DDS, there is a number here. This is for Oakland master files. You can call and say, hi, I'm the representative. I'd like to know who's assigned to my case, or if it's even assigned to a DDS analyst. And calling that master files number, they will give you the analyst that's assigned to your case. If he doesn't have your case in within 2 to 3 weeks, call or email the field office to make sure that it's actually sent to DDS. When you contact the analyst, request to have a barcode to fax records. Some folks, like us attorneys, have access through an electronic records express, what they call it, and that will allow us to upload records, but we need certain information. Initials and reconsiderations are allegedly supposed to be available online for folks on our portal. However, half the time they aren't. They are rolling out a new portal for representatives that should have all of our initials. Currently, the most comprehensive information we have on the electronic filing system for Social Security is really when a case gets to hearing. However, when if there's records that you have to submit or statements or whatever, ask your analyst for a barcode, because that'll be the cover sheet that you put when you fax it. When you do fax it, it's to a special scanner fax machine that that can process the information really quickly. Also, make sure to submit non-duplicative records. If you are submitting something like a evaluation or even records, there are requirements now for some cover language, some language that you need to submit that. And you can find that language in these CFR posts, these CFR sections that I have. Again, you can submit documents by barcode, by fax. You can send it through ERE that I was saying, or you can submit it through an individual response. The barcode will have the specific numbers you need to input. It'll say DR, it'll give you certain fields on the barcode, and that information you can use to submit it. You have to be registered with ERE, of course, to be able to attain that kind of access, or you can submit the function. You have a submit function on ERE. Again, you'd have to be registered with Social Security to be able to have access to that. And just follow up with the analyst to make sure they have the records. Also continue to follow up with the client and the analyst, make sure that they are going to doctor's appointments, talking about their symptoms and limitations. There is a function report that Social Security submits that asks your client to talk about their activities of daily living, what they do, can they cook, do they need help getting out of the house? Same thing, they ask for a third-party function report from someone who knows someone. Be very careful when you submit this information, because I have seen this used against clients more often than it's used for clients. So we'll see oftentimes a judge will say, oh, well, you see you're disabled, you've got all these disabilities, but it says here that you walk your dog for 2 hours. So how are you saying that you can walk your dog for 2 hours, but you can't do this job for 2 hours? You can't walk for 2 hours in this job. Just be very careful about what you report. Of course, the most important thing is to be honest. And walking your dog is clearly not the same as staying as working at his job, but just be a little bit aware that the function reports can be a double-edged sword. Again, at the consultative examinations that we were talking about, they may be scheduled I would just double check that the analyst has all the information that they need, that they have all the medical source statements. And if your client does have to go to a consultative examination, make sure that they discuss their symptoms and their limitations. The approval, yeah, you've been approved. The client can go to the local office to get approved. They conduct for SSI cases, they conduct a non-medical eligibility interview. It's called the pre-effectuation review, or PERC, before someone can receive SSI benefits. It gets really into the weeds about what people are spending their money on, what if they share resources with other people. Also, you will get a notice of award that'll tell you if you're entitled to back pay, how much the amount, make sure the amounts are correct. You can do your PERC in person, at the field office, by phone. Soon they'll have video teleconferencing, and there's also a form you can complete. Some of our clients might be a little bit challenging to reach. And so we do complete the form if it's very challenging for them to do this in person or in the field office or by phone. The form is 14 pages, so just be forewarned. Also, it's advisable if you are able to get your client a bank account or a credit union. It's much preferred to the ways that people get benefits, which is through a Direct Express card. Direct Express is the agency or the company that's contracted with Social Security. It's essentially a debit card. However, if your client loses it, there are a lot of hoops to go through. The customer service is lackluster at best. So if you're able to get a bank account or a credit union, it's highly advisable. Also, that money pops in right away because it's from the US Treasury. This is good, a little bit more high level, so I'm going to go through this really quickly. This is just if you get denied at reconsideration, you can appeal to a hearing by administrative law judge. Some agencies can't, a lot of agencies don't do this. We do, but you can do that online. That form HA 501 is what you want to do. It's essentially the same documents you would need if you are appealing to any of the other levels, except for that HA 501, because it's an appeal for a hearing. And then if you lose at hearing, then again, you can appeal to appeals counsel. Again, the same kind of rules apply, same kind of forms, except there's a different appellate form, but you can do this all online. The other thing is you do submit a brief. So it's really important to have, if you have a representative, if you can have someone who is able to start making the legal arguments. This hearing and appeals counsel is where you really want to start doing those arguments. And then here are the California rate. Here are the rates. If you're living independently, it's 1182. Y'all can see the different amounts. The federal benefit rate is 943, but we also have that California supplement. And so those are, I went through a lot of material. I hope that was helpful for everyone.